Professor of Religion and Society at Fordham University. So thanks so much to all of you, and Jed, why don't you take us away?
Thank you so much, Odette and Kathy and the other organizers, everyone who's put the conference together. I'm sorry that airlines prevented me from being here with you yesterday. I'm glad to be here today. I have my home in the secular American Legal Academy, so the habits of that culture will affect some of what I say. I think a constructive rapprochement between the rule of law and the common good is long overdue. In the Legal Academy, the rule of law has been characterized in a fairly unrelentingly thin and formal way, and most lawyers and scholars have been accustomed to think that they can set aside certainly the category of natural law and perhaps most likely even the category of the common good as either sentimental or duplicitous and invidious ways of getting one's own politics onto the agenda without having to do good, solid cost-benefit kinds of reasoning. So I think two essential points made about the rule of law over the last half century tend to vindicate two things. One is the ordinary vernacular sense that the rule of law is about much higher stakes than the rather thin and formal way in which it's usually discussed. And second, to suggest that the rule of law is essentially connected to the common good. Now, the first of these points comes, I think perhaps unexpectedly to you, from what I gather of your milieu, from John Finnis, who argues, as you know, I guess, that the law forms part of our common good because it enables us to pursue our human ends in orderly and cooperative fashion. I think this is actually a deep point as far as it goes, and not always obvious to the secular lawyer. A legal system in legally good working order, as Finnis defines the rule of law, gives us a common world that we wouldn't otherwise have, a way of doing things together that we couldn't otherwise do. So in other words, when we talk about the rule of law, even in quite a minimal sense, we're already talking about a social architecture that lets us meet and act together in new ways as something that we then have and use in common. Now, the second point about the rule of law leads to what I think is a deeper and thicker set of issues closer to the heart of what we've been discussing. It comes from Judith Shklar, who argued that the meaning of the rule of law always lies in the way that it is filled out in context and tradition, in contrast to the thin Fullerian kind of account. Her own examples were anchored in Aristotle and Montesquieu, but let me give you a more familiar example of what she meant. It's one thing to say, as Lon Fuller did, that a command is not law unless it is promulgated in advance of being enforced, that secret law is not law. It's another thing, larger and more complex in its meaning, if there is so-called secret law in a system committed, as ours is said to be, to open public debate over the exercise of power and the principle that acts of official power should be traceable to the will or at least the consent of democratic majorities. In this larger sense, aspects of the rule of law are stitched into a specifically democratic idea of what it means to live in a free country. That is several bridges further than Fuller thought the concept of law could take him. His famous allegory illustrating the elements of the inner morality of law involves the misadventures of a planistically named King Rex who keeps giving commands that fail to be law. We never get a hint that part of the problem is that he's a king. But for Americans, the rule of law matters because its elements are key joinery embracing in a certain legal and political idea of a free society. That no kings command us may not be entailed by the rule of law, but it is a premise of our rule of law. This point shows the way to another one. What kind of interest the rule of law serves? To hold an idea of a free society, as I've just sketched it, involves a person in a common good that is more than instrumental, as Finnis characterizes his conception of rule of law as instrumental. The idea of the rule of law in a free society makes certain values mine by virtue of my identification with the community that they define. Belonging to a free society cannot be achieved alone and can barely be conceived alone. It's what Charles Taylor has called an irreducibly social good, one which exists only in relation to a social practice and shared ideas that help organize that practice. It's common not only as infrastructure is common, Finnis's important instrumental sense, but also as a language is common. Identifying with the legal idea of a free society is a double-edged sword. I can achieve it only in a shared practice, and by the same token, I can lose that freedom in ways largely beyond my control if the practice fails. It is this sense of the rule of law that people call on when they invoke it in urgent and non-technical spirit, as they often do today. Now, I'm going to turn slightly in order to come back, and I'm going to talk about democracy a little more. I've already adverted to it. It is central to our common good, a thing we do together, a way of being politically free that is possible only because of shared institutions, practices, ideas. And I would like to stress democracy is a certain kind of rule of law. Here's what I mean. Democracy, even more than other forms of government, depends on giving operational meaning to abstractions that have no unique concrete correlate. In a monarchy, you can hear the queen speak and know what she has commanded. But democracy's two etymological bases, demos, the people, and kratos, rule or command, pose a pair of puzzles. Unlike a queen, the people is not a political gloss on a natural fact. It has to be defined by the legal bounds of the polity and of the electorate. To find the people, look at the 15th and 19th Amendments, the Voting Rights Act, the law of naturalization. And when has the people spoken, given a command? When is kratos present? To answer this question, we again need to refer to law, the first three articles of the Constitution, provisions for referenda and state constitutions, legislative procedures. The Constitution itself opens by proclaiming that it speaks in the name of we the people and goes on in Article 7 to specify how that claim can be vindicated by ratification in 9 of the 13 states. Absent that, it would be, even in its own terms, just another pamphlet of the post-revolutionary era. The realization that there is no natural fact called the people, let alone rule by them, sometimes inspires overexcited reactions, jumping to the conclusion that democracy must be just a myth, a story we tell ourselves, or deciding that true democracy must be restricted to certain kinds of up-close and personal, relatively small-scale and simple societies. But this kind of response, which I suspect you have encountered, hugely underestimates the constructive power of law. There may be no natural fact, to take an analogy, no natural fact called the Coca-Cola Company, but it can still order 1 million gallons of corn syrup and 1,000 reams of printer paper. And there may be no natural fact called American democracy, but the legal achievement called American democracy is as real as it is imperfect, and we would know the difference if it were gone. And although the rule of law does not entail democracy, a certain kind of rule of law is a transcendent condition of democracy. Law and its observance uniquely make intelligible the terms of democratic self-rule. Now I want to add another term, trust, and to say how trust works at the meeting place of democracy and the rule of law. Any form of complex cooperation, especially at any large scale, requires people to put ourselves into one another's hands, open ourselves to the risk of betrayal and defection. That's morally dramatic language, but it can refer to very ordinary interactions. Handing your car over for service, reserving a hotel room in another state, following a doctor's orders, or advice, a doctor's advice, I should say. We cooperate because we believe the other person is taking proper account of our interests, even though we know this might not be true. To work together, we must first believe more than we can know. Now, in many instances, the rule of law is an institutional infrastructure that creates the conditions of reliability and lightens the burden of trust. Institutional assurances like contract law or the enforcement of fiduciary rules make cooperation easier. Trust no longer has to be generated and sustained in the course of the very transactions that rely upon it. But democracy is a form of cooperation, by contrast, that relies quite incorrigibly on trust. Citizens put themselves in one another's hands with respect to our most basic interests. We can't do otherwise. Constitutional limits are intended to give institutional assurance that power won't be used inimically to one's core interests, but they do this work in limited and contingent ways. They can as easily become points of division as points of assurance. My colleague Dave Posen and I observe in the Times today that Americans are divided over whether the country is now experiencing constitutional collapse, constitutional renewal, or accelerating symptoms of endemic constitutional rot. We don't ourselves think there's equal reason for all three views, or that they're altogether mutually incompatible. But we do insist that broadly constitutional visions of the society are drawn into our division as much as they provide any kind of commonality. I think that for all these reasons, democracy tends to rely on a sense of common good in the polity that is stronger, thicker, richer than the senses I've used so far. A sense of shared purposes, of mutually acknowledged limits in the use of power, and of other reasons to believe that we are in this together, that being in one another's hands is tolerable. We can say then the following three things about how, in a democracy, the rule of law is drawn into a series of intensifying versions of the common good, in ascending order of intensity. First, democracy is a rule of law requiring legal specification of its operational terms in a transcendent sense. Second, these specifications form integral parts, but not the whole, of our law, which we invoke in arguments over our collective direction, a fuller sense of the kind of political freedom involved, not a Fullerian sense, but a fuller sense of our commitments constitutive of our political enterprise. And third, the thickest, if you will, for democracy to be, in fact, both stabilizing and dynamic at once, democratic practice needs to be able to draw on a broader shared political morality. It isn't news that we seem to lack at least that last, richest sense of commonality, or that the other two are under pressure. Many of you will know the statistics about the condition of social and civic trust in the United States. Americans don't trust one another and don't trust the country's political, media, and civic institutions, and levels of trust have declined markedly since the time when they were first measured in the 1960s and early 1970s. They're lowest among the youngest adult cohorts. If you were just to look at these figures, you might say, these do not seem to be people who would find it tolerable to be governed by one another, people for whom the specific rule of law called democracy would be viable. And I think we must wonder whether this is true. In some ways, our politics today turns on what to do with this situation. So let me, in conclusion, note a few styles of response. It isn't surprising, in light of where I've said we are, that there is a revival of intellectually ambitious nationalism. In this view, trust in fellow citizens depends on an extension of family feeling across the political community. Citizens need to think of one another as parts of themselves, as National Conservatism Conference founder Yoram Hazony puts it. I think this picture misrepresents modern politics. The degree of civic cohesion that it describes may apply in situations of acute crisis, especially threats to collective survival, but most of politics is just not like this. We disagree on where the threats lie, what the problems are, what it is that we have in common, and what to do about it. And efforts to insist upon or generate a thicker form of commonality on the underlying model of family or clan, I think, ironically tend to deepen rather than overcome division under genuine complex circumstances of modern politics. Now, the modern classic alternative to this kind of nationalism is, of course, constitutional patriotism. Our colleague Aziz Rana is perhaps its most important critical student, treating it under his rubric of creedal constitutionalism. Loyalty to constitutional process has been a powerful organizing principle for some Americans sometimes, but it's buckling, as I said, under the weight of our present political division. I would say, as the beginning or the glimmering of a third way of thinking about it, that a basic democratic hope is that democratic activity itself builds things in common, generates its own resources for further democratic life. And I think this can be true. But when we are divided and mistrustful, the circle can be vicious rather than virtuous. In those circumstances, it can be true that the more we are politically activated, the harder it is to have democratic politics together. What's at stake in the future of democracy and rule of law, it seems to me, is whether we will fall back into what has been the default experience of life under states of any size and complexity, a sense that the deeds and choices of the powerful are, for the rest of us, a kind of fate, and that we can't do much beyond hoping for good kings and trying to escape the notice of the rulers we actually have. The democratic alternative to that time-worn political fate is a kind of common good in which we collectively give shape to the terms of our common life on the premise that we matter together because of the ways that we each matter. Whether we keep that capacity and even extend it is a very serious matter. And with that, I am glad to turn the problem to Aziz.
So first, I'd just like to say thank you to Kathy, to Greg, to all the organizers of the conference. It's really a pleasure to be here. And thank you, Jed, for those really stirring remarks. And in many ways, I think what I want to say is a kind of extension of what you've developed, talking specifically about the American predicament at this moment. So that there's a general conversation that's taking place that folks will be familiar with about whether or not the US is in a constitutional crisis. And the way that that conversation has typically proceeded is to frame it as a debate effectively about checks and balances. Do we have a president that's running roughshod over a system of checks and balances? And I would say that I think this really profoundly undersells the seriousness of the moment. So Jed highlighted a variety of different approaches that are being debated about how to think of our own constitutional and legal present. And the argument that I would present is that rather than imagining what we're experiencing right now as a crisis, it's better to think of this moment as really the breakdown or indeed the collapse of the mid-20th century American constitutional project. And this is really significant because when we think concretely about the idea of the rule of law in the US, it was this constitutional project that gave it substance and also ensured that when we talk about the rule of law, we're not just talking about there's legal process that you follow, but that it actually has an underlying ethical set of commitments. And so what I'd like to do is to talk a bit about well, what was the compact, how it emerged, why it's been breaking down, and then I want to turn and let's say some briefer reflections toward the end to why I think the breakdown of the compact is actually generating perhaps as its most concerning element a limitation or diminution in our collective morally evaluative instincts to address the moment. That the breakdown is having a profound effect on our ability to make assessments about what we understand to be the good that we share and that we'd want to promote in the world. And then I want to end with some reflections about renovation and recovery, focusing in particular on civil society. All right, so first, what do I mean by the mid-20th century compact? And when I describe the elements, they should be fairly familiar because really it's a description of the American project that we've all come to know if you grew up in the US in the latter part of the 20th century or in the US at the beginning of this one. It has 5 different elements. The first is the idea that the Constitution is meant to fulfill the principles of the Declaration of Independence, especially the commitment to universal equality, equal liberty for all. Broadly speaking, we can think of this as racial liberalism as emblazoned in cases like Brown versus Board of Education. Tied to that is the idea that not only is there a commitment to equal liberty, there's also an anti-totalitarian embrace of civil liberties, of individual autonomy against overweening forms of state power, the centrality of things like free exercise and free speech as bound to the notion of constitutional commitment. Third, there's absolutely an embrace of market ethics and the idea of market capitalism, but critically, this notion of economic liberty that's a kind of pair to civil liberty, the idea that having property rights is akin to having a private space that's free and autonomous from overweening government authority, was nonetheless supposed to be regulated, and regulated on behalf of a vision of the common good organized through a notion of social welfare, so that there's various kinds of constraints that are built into an unregulated market economy so that you have a general distribution of goods such that nobody truly goes wanting. So that's the third element. The fourth is a commitment to representative government. And in the US, it's a version of representative government that's nonetheless constrained by a notion of checks and balances, that there's no single institution that's supposed to have overweening power. And this is precisely why you have a judiciary that's supposed to guard both individual liberties and checks and balances. And then there's a fifth component, which I think is essential to discuss in this moment in time, which is the American Constitutional Compact was not only an internal project, but it was a global one. And the idea was that the reason why the US after World War II had an appropriate authority to engage in global leadership was because its inherent essence were these constitutional commitments, and so its power was the preservation and projection of constitutionalism globally. Hence, a commitment to multilateral institutions, a commitment to the idea of international law as operating both abroad but also in interactions between countries. I want to just note up front that there have always been instabilities within each of these elements and profound critiques about the extent to which the US in fact lived according to these principles. And we can talk about that in question and answer. In much of my writing, I tend to be quite critical of elements of the 20th century project and to what extent could it actually on its own terms live up to these ideals. Nonetheless, these are the basic elements. How did it emerge? Part of the story that is the product of the 20th century is the idea that this has always been the meaning of the country. And part of the reason why that's felt self-evident is because the US Constitution is perhaps the hardest constitution in the world to formally amend. And that means that changes to the Constitution don't take place through a new document or new language primarily, but instead through presidential leadership, landmark statutes like the Voting Rights Act, and judicial action to say that these landmark statutes are now part of a constitutional compact. What that does, these informal shifts paper over the fact that there's profound breaks in the meaning of the constitutional project across time. And so rather than as something that one can project back to the founding, the truth is, what I described is the result of very specific dynamics between the 1930s and the 1960s. I don't have time to go into all of them, but I'll just highlight 3. Great Depression and the New Deal, which generated a powerful working class labor movement that was able to overcome many of the veto points and counter-majoritarian elements of electoral politics in the US, so as to implement things like collective bargaining through the National Labor Relations Act, Social Security, unemployment insurance, etc. So to impose a vision of the market that's supposed to be constrained by an account of the common good and of shared prosperity for all based on a theory of economic equality. Second, World War II and the Cold War, and in the ways in which both of those dynamics ended up emphasizing civil libertarian values that are embedded in the way that we think of the US as distinct from other kinds of totalitarian foes. Also central to the Cold War project was the fact that the Cold War took place against the backdrop of decolonization, global decolonization. So I'll have that as like the third element, along with World War II, Cold War, global decolonization, which meant that the US found itself as a global power at precisely a time when most of the world, which was a non-white world, was claiming equality on the international stage and required, as a result, the US both to provide an appropriate political and economic alternative to the Soviet Union, and also to embrace notions of equal liberty for all, regardless of race, ethnicity, religion, membership within the country. All of this ends up leading, in the context of domestic social movements, to the achievements, the landmark achievements of the 1960s, like the Civil Rights Act and the Voting Rights Act. It also has this very profound effect of producing intense social cohesion within what we can think of as the national political class in the US. It pushes the left toward a center left, the right toward a center right, an agreement around the importance of ameliorative change across a range of various topics, as expressed by institutions like the Supreme Court during the 1950s, the 1960s, the 1970s, the Supreme Court of the Warren Court and Brown versus Board of Education. All right, what happened to break down this compact? There were long-running developments, basically since the 1970s, that chipped away at all of the elements that gave strength institutionally to the mid-century compact. And here, I just want to highlight a few points in time. So the first point is the way in which 1970s transformations in the nature of the global economy and the collapse of industrial capitalism really ended up undermining the power of labor and unions and something like an organized working class to provide the types of supermajorities to sustain the achievements of the mid-20th century. And that transformation had huge impacts on party identity and really the alterations in the nature of American party politics going forward. The second big thing was the end of the Cold War. We tend to think of the Cold War, understandably, as having constraining effects on the left, as producing various kinds of McCarthyite crackdowns on left-wing or socialist politics. But one of the things that's central that the Cold War also did is that it constrained the far right. It placed various kinds of pressures on right-wing politics to say, in order to succeed in an existential struggle against the Soviet Union, you actually have to ensure that there are ameliorative improvements for working people, for minorities, precisely because of the fact that there's this alternative, and you're trying to win hearts and minds in a global South that is overwhelmingly non-white. It's one of the reasons why, over time, if you listen to somebody like George Bush Jr. or McCain before he died, they sound a lot like Obama. And Obama and McCain and Bush sound way more like each other than any of them sound like somebody, for instance, like Trump or within the current kind of Trumpist formation of the Republican Party. When the Cold War ended, those kinds of cohesive constraints that shaped American politics effectively disappeared. And what that did is it liberated right-wing politics to pursue a very different kind of direction, and it's meant that the right has in some ways reverted back to what had been more traditional forms of conservative politics in the US, emphasizing fundamentalism around both market and race. And then there's a third element, which is the financial crisis. The global financial crisis had a cataclysmic effect on what we can think of as center-right and center-left politics internationally. And this way, the US is just of a piece with all of those developments. And part of the problem, though, was that despite the fact that in theory, the global financial crisis in undermining what are called as quote-unquote neoliberal or market deregulatory policies might have been a boon for social democratic efforts. In truth, because of the transformations in the economy, the weakness of labor, the fact that in the US, the percentage of people that are unionized in private employment went from 25% to 5 or 6, it meant that effectively the right, and we see this globally, was much better equipped to capture populist antipathy to the politics of the center. And in the US, all of that intersected with a very particular set of constitutional problems, which is the US electoral system is notorious for being incredibly riddled with counter-majoritarian elements. In other words, it's very, very difficult to get past through Congress any kind of meaningful landmark legislation, because the electoral system is built not really on the principle of one person, one vote, but on geographical representation through the states. And that shapes who ends up in the presidency. It shapes who ends up on the Supreme Court through the relationship between the presidency and the Senate. And what it also does is it creates a dynamic in which, if you have a particular coalition that's geographically empowered by electoral dynamics, in other words, in large geographical spaces but with small population centers, then you have a dramatic thumb on the scale in terms of your voting power. At various points in American history, geography was not necessarily an indicator of partisanship. There was just as much political radicalism in Wisconsin, let's say, or in places that were less populated and quite rural than in New York City. But one of the things that had happened because of the transformations of the nature of the global economy and its effects on domestic politics in the US is that essentially geography became closely aligned with racial diversity, ethno-racial diversity, and political identification. And it reached a point where effectively in the US, a minority party that was committed increasingly to defecting from all of those different elements of the mid-century compact in the form of the new kind of Trumpist frame, was able to assert much more political authority than it had based on pure votes. And so it's why you have a situation of multiple presidents being elected while losing the popular vote, and then through the power of the Senate, because the Senate is organized around geography, not through population, transforming the nature of the Supreme Court, so that Trump alone, despite losing the popular vote in 2016, was able to get nominated and confirmed to the Supreme Court 3 justices, while Democrats since '68 have only been able to get nominated and confirmed 5 total. All of this created a framework whereby effectively what you had is a much stronger political right in its more unconstrained form by the time we get to 2024 than what we'd seen previously. And then, because of the paralysis of the legislative branch and its inability to address various kinds of prevailing social problems under the Biden period, you have real intense anti-incumbency operating in the US as well as globally. It sets the stage for Trump's return unconstrained, especially in a context in which he'd attempted effectively to subvert an election in 2020. There had been no meaningful consequences for that effort, unlike similar circumstances in other places like Brazil. And so he comes back emboldened, committed to aiding allies, undercutting enemies, and in a setting in which he's surrounded by loyalists that have an extreme commitment to eliminating all 5 of those different elements. But interestingly, because they don't actually have a galvanized and clear majority coalition, without the ability to transform something like constitutional collapse, so the chipping away and now the breakdown of the system, into a new regenerated order that's built around, let's say, a far-right political vision of constitutional meaning. Okay, where does that leave us in the moment? I think there are ways in which we can make arguments for and against the politics of the mid-century compact. But I would say the greatest danger in terms of thinking right now about constitutional collapse is the way in which that mid-century compact, because it was so central substantively to the ethical values we connect to the meaning of the rule of law, its removal has created what amounts to a kind of moral morass. And the reason why I would say this is to just take a step back. The success of those achievements between the 30s and the 60s was not really ultimately about the success of litigators making arguments connected to specific doctrine or text in the Constitution. It was because it was a product of sustained civil society activism around a set of moral truths that we can think of that were oftentimes made in explicitly religious terms, sometimes made in secular terms, but were collectively understood as a common good. We can think of somebody like Martin Luther King's invocation of the Constitution as an aspiration to fulfill a particular ethical vision of how the world was supposed to be organized. We can say the same thing about the labor movement. We can say the same thing about efforts of decolonization that American activists found themselves committed to. In other words, The depth of that project was because it gave language to a vision of the good. What happened over time, and we can see this specifically with the Supreme Court, is that the repositor of who was supposed to protect that vision principally became the institution of the Supreme Court. The thing that did the most to legitimate the Supreme Court in the 20th century was Brown versus Board of Education. It was an institution that faced massive pushback before then, was oftentimes treated as a site of elite control. But because of Brown and because of a set of decisions in the mid-20th century, it was viewed as a protector both of the constitutional project and of the ethical vision. And then what happened? Over time, and we can go through the doctrine, I don't have really the opportunity to trace it out in great depth here, but the court essentially ended up participating in a steady chipping away of all of those elements well before Trump, in the context of the transformation of who's on the court. But then post-Trump, the court ended up having this very specific role, which is, for collective life, it's an institution that is understood as the protector of the mid-century compact. And so when the court acts, let's say through its shadow docket, to strike down injunctions limiting Trump's actions, or when the court refuses to hear specific cases because it says that it's a political question or it's outside of its own area of expertise to make assessments about issues related to immigration or national security, it has the authority of the moral project. And yet what it is doing in practice is facilitating the breakdown and the entrenchment of a new form of executive power. So that the court's function is precisely because it's this hinge institution that can claim the moral authority of the old mid-century compact, is in this moment to kind of speed run the breakdown. And then this has all sorts of disorganizing effects for the moral conversations we have. We're living in a moment, so I have about 5 more minutes. Yeah. So we're living in a moment in which the executive branch is engaged in intense forms of violence, both domestically and overseas, from mass roundups of immigrants to the shooting and killing of protesters, to the initiation of what should be understood as illegal conflicts overseas with mass effects as a result. And yet, this is precisely the arena in which the court has said, effectively, these are not questions that raise constitutional matters. And what that does is it means that domestically in the US, there's a whole range of deeply, one might say, immoral actions that are being carried out by government, but they're completely disconnected from the language of the rule of law that we've built over time as a way precisely to talk about morality. And so to the extent that they get debated on grounds of, well, should extrajudicial killings in the seas be thought of as legal or not, or is it actually consistent with past precedent, rather than precisely what was supposed to be the achievements of the mid-century project, which was to understand a set of ethical restraints as built into the idea of the American rule of law. And here, the primary institutions and legal actors, the most elite figures within the legal academy as well as the legal profession, are participants in undermining our ethical faculties to be able to recognize as moral violence. So where does that leave us? I think what it leaves us is the central importance in this present moment of contesting, not just on legal terms, but on moral terms, precisely the kinds of activities that we see, and we see this already emerging in places like Minneapolis in the context of debates around the treatment of immigration. But I also think it highlights that the reason why this has been effective is because of the hollowing out of all of the intermediate meaning-making institutions that gave teeth and substance to that vision of the rule of law. And here I mean churches, unions, political parties, professional associations, bar associations, medical associations, law firms, you name it. And that over time, these institutions that provided the organic world that people inhabited so as to be able to give them clear indicators about what was consistent or inconsistent with their own sense of ethical commitment, the fact that these have been constrained essentially has undermined our ability now to pursue sort of like thick responses, both at the local but as well as at the state and national level, to precisely the kinds of activities we see. And indeed, to the extent that there have been successes in this moment, it's because, while hollowed out, they're not totally defunct. And so it's really a call in the present for an argument from both risk-taking and political courage, but also effectively moral renewal within precisely the intermediate institutions, from bar associations to unions to churches, to kind of reclaim what had been their primary function. If this had been delegated to a Supreme Court that was supposed to provide all of us with protections against an attack on the rule of law, the lesson is nobody can ultimately have these rights preserved if they're delegated. They have to be renewed within the terms of the lives that we lead and within our schools, neighborhoods, communities, and institutions that we inhabit. Thanks.
Okay. Yeah, thank you very much for all these wonderful contributions, and especially thank you for the invitation. I really feel very pleased and honored to be able to speak here. But now we're going to have a kind of change of perspective, because I was asked to present some challenges from a German and European perspective, and also a perspective how to go forward with it. And it's very difficult, and I should explain the different uses of the concepts, but there's no time for that. I hope it will be understandable as well. I will approach the problem on two levels. The central debate, in the German debate, concerns the relationship between the rule of law and democracy, as we had already heard. And I will begin there. In section 2, I will illustrate this with an example from Germany, and then I will consider which fundamental norms are at stake and focus particularly on the concept of freedom. And finally, I will explore a possible contribution of Catholic social teaching and its understanding of the common good. 1, rule of law and democracy in Europe. An important key concept in Germany is the democratic constitutional state. There, democracy and rule of law seem to be inseparable. And that's a wonderful concept, but there are certain tensions, and we are experiencing these tensions at the moment. Democracy as the rule of people rests on majority decisions. For this to function, rules are necessary. The most basic rule is a willingness to relinquish power when others achieve a majority in elections, as says Adam Prevosky. But in so-called liberal democracies, difficult concept, this also includes the rule of law, as we all know, which manifests itself in strong institutions, especially well-functioning courts. Accordingly, the basic democratic idea is realized in a strong constitutional state with separation of powers. Yet, for several years, democratic theory has debated whether precisely the strong rule of law character might weaken democracy as a form of government in which majorities decide. The concern is that crucial questions are no longer decided in parliaments, but in courts. In this perspective, the rule of law is no longer the support of democracy, but its opponent, because majority decisions are restricted in order to uphold certain fundamental values. This development is closely related to the political transformations in Eastern Europe after 1989, where courts were given very significant roles. Hungary provides an example. During the 1990s, the newly established Constitutional Court decided fundamental political questions such as abolition of the death penalty or procedures for addressing the socialist past against the will of parliamentary majorities, with good reasons. But in Hungary, Viktor Orban then brought about a drastic disempowerment of courts and the development of what he calls an illiberal democracy. Beyond this problematic development in Hungary, which is really, really serious, there are underlying questions like, for example, where are decisions made, within parliaments or within courts? From the perspective of limiting power, rule of law, it is necessary that parliament and courts to be distinguished. Yet problems arise when they diverge too far from one another, because citizens may then no longer perceive decisions as their own. Here rises again the question of representation we were already talking about. The debate on this is important, and it must not be left to the right-wing populists as we are experiencing at the moment in Europe. So conclusion one, there is a tension between the principle of majority rule and the principle of rule of law, but both pillars are needed. And now the German situation. In Germany, this challenge currently appears in the debate over banning a political party, the AfD, the Alternative for Germany. The AfD is regarded as partly right-wing extremist. At the same time, however, the AfD has many supporters, about 20%. Yeah? If the party were banned, some citizens might claim, and they already do, that their voices no longer count, further eroding their trust in democracy. On the other hand, there is a serious risk that the AfD itself could undermine the very foundations of democracy, its principles and institutions, and they already are doing that. It may, for example, reject what you called in your paper you sent us before the shared humanity. Yeah, no country is more aware of such dangers as in Germany. And the decision now is extraordinarily difficult how to decide in this question of banning the party. This is a formal level. But the question how to deal with the AfD supporters also arises within a civil society and also within church. 2 years ago, the German Bishops' Conference anonymously issued a widely discussed position paper entitled "Ethnic Nationalism and Christianity are Incompatible." It is an excellent document. I quote, "Right-wing extremist attitudes and concepts fundamentally aim at exclusion and marginalization. Within this radicalized way of thinking, the equal dignity of all human beings is either denied or relativized and thereby declared irrelevant for political action. For the Church, however, it is clear every human being possesses an unimpeachable and inalienable dignity." End of quote. This very important document clearly explains why right-wing extremist thinking is incompatible with Christian faith. At the same time, it underscores the importance of dialogue with people who are still somehow receptive. With people who are receptive to right-wing extremist ideologies to a certain point. And it's very difficult to define where is the point. To whom can I still talk and where is it impossible? The Church here assumes an important role as a civil society actor and intermediate institution, defending the rule of law formally and the central principle of human dignity materially. And I think this is what we need at the moment. So conclusion 2, the Church can and must take stand wherever democracy and the rule of law are threatened. 3, the problem of freedom. This brings us to the question of the fundamental values of democracy that the rule of law is meant to defend. I have already mentioned the inviolable dignity of the human person, an extremely important concept in Germany. It's Article 1 of the Basic Law. it's interesting, the concept of the common good does not play such an important role. Instead, concepts such as social justice and solidarity are more central. Therefore, I approach the question of some kind of common from another angle through the crisis of the concept of freedom and the tradition of freedom. And I never know if I shall say freedom or liberty, because in German it's only one word, and it's a very different tradition from the US-American tradition, yeah? But I think many of the current problems of democracy revolve around competing understandings of freedom, and I will address only one. Democracy presupposes an understanding of social freedom. Freedom as a social relationship in which freedom becomes possible only through the social order. It's a concept influenced by, from Hegel to Odette and many others, yes? And in the recent years, however, this has begun to change. The idea of the liberal, also in the German-speaking context, is shifting toward the libertarian. The shift directly affects the question of the rule of law. Several socialists currently diagnose that citizens, in the name of self-determination and self-realization, are rebelling against democratic institutions precisely because those institutions place limits to their freedom. Freedom then is understood as an individual property, and that is reified and reduced to a claim. Whenever this claim is not fulfilled, it may be experienced as an injury or as an humiliation. Some scholars therefore speak of a humiliated freedom, a gekränkte Freiheit. Amlinger Nachtwey wrote a very important book on this. And this humiliated freedom is destabilizing social coexistence. Conclusion 3, some difficulties facing democracy are rooted in a reduced concept of freedom. Point section 4, potentials of Catholic social teaching. I'm convinced that Catholic social thought and Catholic social ethics have something to contribute here. My starting point is the understanding of the human person. The principle of personhood, or I think you call it a principle of dignity, in German it's more like principle of personhood, emphasizes that the human person is rational, unique, valuable, possessing inherent dignity, and at the same time a social being. We depend on others. We cannot exist without one another. This fundamental insight serves as a normative compass that guards against drifting toward extremes. We could talk here about solidarism, but it's not enough time for that. From this understanding on the person, Catholic social teaching has the potential to introduce a distinctive concept of freedom, freedom in social relations, into the public discourse, and we should do that. To do so, however, the Church must abandon, or certain circles must abandon, the skepticism towards freedom that still persists in some quarters, the long shadow of the 19th century. Despite its distortions and misuses, the appropriate response is not suspicion toward freedom, but its defense. We can defend freedom because it is not a libertarian freedom, but in its social dimension. We can defend social freedom. At this point, the idea of the common good enters the discussion, precisely because human beings possess a social nature. The well-being of the individual, as we have heard, cannot be separated from that of the others and of the community. But which common good are we talking about? Mater et Magistra, 1961, offers a definition. Those involved with public authority, they must take account of all those social conditions, we heard about that, which favor the full development of the human personality, the flourishing, yes? It's about the conditions. And On the one hand, the statement makes clear that the common good must not come at the expense of the individual. On the other hand, it shows that the individual depends on realities beyond himself. Life and the development of the person have prerequisites that are social in nature. The common good is necessary for the flourishing of the individual. That's very close to what we heard before. At the same time, the concept of the common good is vulnerable to misuse, and perhaps I'm more skeptical than some others here. And during the 20th century, we had an interesting discussion in the German-speaking countries, especially in Germany and Austria, what we call the controversy between Jesuits and Dominicans. The dispute revolved around how the common good should be determined. Do we already know, a priori, before, what is the common good, and then such that it simply needs to be implemented, as some Dominicans argued, or can it instead be determined only a posteriori, afterwards, within a specific procedure, through balancing interests in favor of the good of all members of the society? The latter position was defended by the very important German scholar Oswald von Nell-Breuning. And I think if one takes Mater et Magistra seriously, only the second approach can be appropriate within a pluralistic society. Thus, if we defend the common good, it must be one that is not exclusionary and not achieved at the expense of the liberated freedom of the person. For this reason, efforts currently underway to define the common good a priori and subordinate everything else to it must be rejected. Those approaches ignore the crucial developments in Catholic social tradition, particularly those expressed in Dignitatis Humanae. And I think we must not allow the fundamental concepts of Catholic social teaching to be misinterpreted or instrumentalized. So, conclusion 4, the concept of social freedom must be defended against libertarian interpretations, and the concept of common good against integralist ones. And so my short, very short last point, concretions. What we should therefore advocate is an understanding of the common good that corresponds to the principle of personhood or of dignity, and that provides the conditions for human flourishing. Such an understanding must necessarily be processual and dynamic, and thus close to what is currently described in social movements as commoning. The shared good, the common, emerges through practice, not identity, from community gardens to housing initiatives to cooperative energy projects or whatever. I would like to encourage cooperation in these areas between church and non-church actors. One might object that such initiatives do not change structural conditions. That may be true, yet both tasks are necessary for social ethics. Working towards more just structures that enable the realization of the common good and initiating alternative practices. Besides, I do not see commoning as an alternative to the democratic state based on the rule of law. Rather,
I think you may have accidentally turned it off.
no, it's low battery. Okay. Besides, I do not see commoning as an alternative to a democratic state based on the rule of law. Rather, it remains dependent on this framework and can and must transform it at the same time. Finally, Catholic ethics always has been also an ethics of models. A model does not mean that others must live exactly in the same way as I do or whoever does. It simply shows that things could be different. We need models that demonstrate how life might be otherwise and that radiate into society. but not in the sense of Patrick Deneen does. Yes, it's another model. In this way, democracy becomes tangible and practicable, something people can experience, and this may take the wind out of the sails of those who seek to hollow out democracy and the rule of law. So, conclusion 5, working toward just structures is just as necessary as developing concrete practices in cooperation with others, because things could be different. Thank you.
Many thanks to my fellow panelists and to Greg and Kathy for organizing. I apologize in advance. I'm going to speak really fast. I have more words than I have time allotted. I am, however, luckily, a New Yorker, and we're known for being fast-talking. That may be part of the natural law. I start with Scripture. Psalm 119 has a series of 5 phrases. Here they are. How I love your law, O Lord. Your command is ever with me. Your decrees are my meditation. Through your precepts I gain discernment. From your ordinances I turn not away. Those 5 nouns, law, command, decrees, precepts, ordinances. The key sentiment, appreciation, admiration, devotion, even love for God's law. Now, of course, this is a conference about civil law, not divine law, and no one's going to write psalms or wax poetic about texts written in technical legal language, right? We know that. Nevertheless, I believe that civil and statutory laws are indeed indispensable bedrocks of our way of life. They are worthy of loyalty, reverence, even love. Respecting and admiring the Constitution and civil statutes is a commendable virtue. Ignoring, violating, and flouting them is a serious vice. But of course, the problem is that the instruments of our rule of law are not universally hallowed or even respected at this particular moment in our national history. We have a current administration that's callous, dismissive of precepts and legal customs that it finds inconvenient, and it frequently flouts the textual specifications of the U.S. Constitution as well as received norms associated with it, such as the orderly separation of powers, as previous speakers have spoken more eloquently than I ever will. As we witness these fierce attacks on the rule of law, many of us stand by in shock at the blatant disregard for the rule of law and of specific laws and legal norms on many occasions. Professor Aziz Rahman does us a great service. He captures in wonderful phrases like the American predicament of the current moment and the constitutional crisis of the 20th century constitutional project. These are things that we benefit from knowing about, hearing about, and the analysis of all my panelists has been excellent. The current administration has indeed demonstrated a stupefying lack of respect for the rule of law, and it would make the author of the Psalms blush, turn over in their graves. Pick your favorite metaphor. I have to keep reminding myself further of the distinction between actual violations of the rule of law on one hand and a range of other objectionable features of the current administration on the other hand, ranging from wanton cruelty to swaggering vulgarity, to blatant cronyism, to techniques of intimidation, relentless self-promotion, attention-hogging, strategic distraction. None of the latter are technically violations of the rule of law, but the style by which one exercises government power is ultimately of a piece with the substance and legality of administrative measures and policies. Okay, enough of the diagnosis for now. Let's move on, as medical professionals often do, to the prescription. What do we do now? That's the title of this afternoon's panel. What's to be done regarding leaders who do not, shall we say, who are not good rule followers? As a sometime observer of previous interactions, even confrontations between civil leaders abusing power on one hand and religious leadership championing faith-based principles of social order on the other hand, I jump at the opportunity to push the ball up the court a little bit. That's a basketball metaphor for you March Madness fans. This is the right month. Maybe my enthusiasm for this project, by the way, might spring from deep in my Jesuit DNA, as the Society of Jesus has a long history of sustained reflection on legitimate opposition to autocrats, and you know the story there, right? Jesuits are accused of all kinds of subversion, and I think the kind of subversion that turns out to be, at least I'm proud of, is where we supply a subversive grammar for legitimate opposition to tyrannical behavior. Any good grammar starts with verbs. Let me recommend this collection of verbs and verbal phrases to anyone in search of deciding on a course of action. Try these: resist, challenge, push back, denounce, mobilize, get involved, and my favorite, box them in. More important than generating a further thesaurus entry is the task of sequencing recommended courses of action. I find myself starting with that crime-fighting slogan, we all know it, me from the New York City subways: if you see something, say something. Don't allow violations of law and legal norms to go unnoticed and thereby unchallenged. Sunlight is indeed the best disinfectant that we have. Next, after this initial exposure, go ahead and join your own personal efforts to those of many others who are networking, organizing into effective coalitions to oppose such abuses. We are already witnessing an impressive series of massive nationwide efforts with the No Kings rallies. We had one June 14th and October 18th of last year. There's more planned for the future. In the meantime, the good citizens of Minneapolis have engaged in courageous demonstrations to call attention to the brutality of ICE raids in their city, which included, of course, the shedding of blood and the loss of life by two innocent protesters. The loss of Nicole Good and Alex Pretty is a poignant reminder of the perennial reality that a high price has to be paid for such prophetic acts of witness. There are many creative ways of exposing abuses, expressing outrage, and creating conditions for change. Social activist Gene Sharp once listed about 200 methods of nonviolent action, clever techniques for contributing to social reform. All of them are peaceful in nature, with some being downright hilarious in the categories of satire, targeted mockery. At some point, any successful social reform movement, such as any initiative to rekindle respect for the rule of law in our present moment of national trial, they will have to adapt measures to consolidate the form of its opposition to injustices. The civil rights movement achieved this task of consolidation by ramping up its level of organization, while the Occupy Wall Street movement, around 2011, by and large failed to navigate this challenge of taking this quantum leap upward. And Dr. Aziz Rahma does us a great service in his description of the need for a transformative reconstruction of the American constitutional project. Another great phrase. That eloquent phrase captures the summons of many people to rise to the occasion of the present moment, presumably to follow up with specific legal and administrative recommendations for redress and remediation. In describing just above the courageous actions of the protesters against ICE raids, I've already dropped the word prophetic. And this word signals the transition in my treatment here of the crucial question that brings us all here today. What is the distinctive contribution of specifically religious voices to the struggle to uphold the rule of law? What guidance would I suggest for religious leaders in particular at this moment of national peril? We are by no means starting from scratch here. Ever since the prophet Nathan confronted King David and his misdeeds in the 2 Samuel chapter 12, we have witnessed a long and impressive tradition of prophets calling down divine judgment upon despots, of speaking truth to power, of responses, carefully calibrated or not, on the part of religious voices and faith communities to governmental abuses and encroaching authoritarianism. If you're wondering if such prophetic denunciation and opposition is ever effective, just ask, say, Ferdinand Marcos or Robert Mugabe or other oppressive leaders in the late Cold War Poland or the late apartheid-era South Africa or any number of other deposed despots whose abuses sparked reform movements often spearheaded by religious leaders. Each case is different, but the pattern is unmistakable. The result need not be a fleeing dictator. It could well be the kind of reform that reestablishes respect for the rule of law and ushers in concrete steps to enact a return to fully constitutional governance. Or, for more nuanced analysis of the limits and perils of prophetic denunciation, just ask our friend Dr. Kathleen Caveney, the academic force of nature behind this conference. Her insightful and meticulously researched book, Prophecy Without Contempt, subtitled Religious Discourse in the Public Square, does a brilliant job of addressing the conditions under which prophetic jeremiads aimed at holding power to account might prove either effective or excessive, and therefore not constructive. Caveney contrasts and here's two phrases of hers, the language of practical deliberation with the outraged rhetoric of prophetic indictment, and she probes the question of how to, another quote, control out-of-control prophetic rhetoric of the sort we are all too familiar with in the heat of battles in the culture wars, end quote. Further, it's easy to agree with her oft-quoted contention that these days we are desperately in need more of moral teachers than of culture warriors. Too many of those. Yet nothing she says in that book or anywhere else, to my knowledge, eliminates the possibility of forging a constructive role for faith-based critique of political abuses, especially if we settle on the proper style of that discourse. We were familiar with further appropriate caveats even before Caveney documented them so well. Among them is the possibility that religion may find itself being used for partisan political purposes, captured by the political forces and co-opted in cynical ways that call faith-based activism to lose its bearings and compromise its message. The ongoing debate over the phenomenon of Christian nationalism has brought to the surface once again the many risks regarding sacrificing the integrity of the gospel message and indeed the cautions associated with any involvement of religion in public life, where red flags still abound regarding the instrumental use of religion to divide the populace rather than uniting people of goodwill by appeals to conscience and in service of, yes, the common good. The best way to prevent religion from being corrupted for partisan purposes is for religious leaders to keep the focus on the invocation of absolute moral and ethical principles and the workings of well-formed consciences, all of which are squarely in the wheelhouse of religion in the first place. In its consistent appeal to the better angels of our nature, religious ethical thought has a felicitous way of filling the moral vacuums that we might encounter with departures from the rule of law, because religion is capable of proposing appealing moral visions that tap into the deepest longings of people for moral order in the universe. It stands up for decency and moral behavior that must be practiced universally by all parties, even the most powerful, especially the top officials of any government to whom citizens have extended a sacred trust. And if this all sounds a bit too abstract for full comfort, recall that the ethical guidance offered by religion is eminently concrete, with core messages regarding care for the poor and the outcast, extending a hand of assistance to refugees and to marginalized peoples. These acts of mercy and justice are fully expressions of prayerful faith. They're not planks of some polarizing agenda. Such compassionate actions do not need to be sold as anything except divine directives for a religious mission to communicate God's love for all people without exception, in line with their innate human dignity. So precisely how have religious voices risen to the occasion and met the current moment of corruption and departures from the rule of law? Just to cite examples from my own Roman Catholic community, the American bishops are witnessing a marked rise in public affairs advocacy just in the last 5 months. That's especially remarkable since recent decades have found the U.S. Conference of Catholic Bishops too ideologically divided on to take any public affairs stances with a unified voice beyond opposing abortion and life issues. But something must have clicked at the USCCB's annual plenary meeting last November, when the assembled bishops passed nearly unanimously a brief but powerful statement, much of which Vincent Rogeau read to us earlier, thank you, Vince, advocating for solidarity with migrants and better treatments for migrants and refugees in the United States. It was the first time in 12 years that the bishops issued what they call one of these special messages. Perhaps the forging on that occasion of broad Episcopal consensus, there were just 5 dissenting votes, on the need to speak out in the face of immigration crackdowns and other repressive federal policies broke the seal of relative silence and encouraged subsequent pastoral letters and statements from individual bishops and groupings of bishops by state or region, as we have seen a large number of these just in the past 5 months. Similarly, the Catholic media, represented here very well, by the way, has been busy covering numerous statements of individual bishops and groups of bishops exasperated over an excessively muscular foreign policy and calling for greater restraint and less reliance on the use of armed forces by the U.S. Abroad. I have a couple paragraphs here about those. You don't need to hear about their objections raised by many bishops to what's happening in Venezuela, the saber rattling from everywhere from Greenland to Cuba to the Middle East. I'm very proud of Cardinals Blaise Cupich and Robert McElroy of Washington. There's been others. They speak with conviction. They speak with credibility. McElroy has a doctorate from Stanford in political science. So it's noteworthy that on these two issues, foreign policy and on migration issues, the U.S. Episcopate has been able to cite frequent pointed expressions of concern on the part of Pope Leo, who seems to want, is a little reluctant, right, as an first American Pope, but he seems to want to use these proxies, and then they can quote him and his few statements, and then even recently, Vatican Secretary of State Cardinal Pietro Parolin bemoaned how the rush to war in Iran shows how, here's his quote, the force of law has been replaced with the law of force, and that is relevant to our conference. So time doesn't allow for much further things. A whole bunch of other great bishop statements have happened. The only one I want to call attention to took place last month in February when the USCCB, joined by Clinic, that's the Catholic Legal Immigration Network, Inc., it's sponsored by the bishops, submitted an amicus curiae brief in the pending Supreme Court case of Trump versus Barbara et al., which hinges on the legality of recent executive orders threatening the continued recognition of the principle of birthright citizenship, until now a universally recognized right under the 14th Amendment. The mode of argumentation within this document, which I recommend to you, combining as it does many authoritative sources in Scripture and Catholic theological tradition, as well as legal precedent, is well worth the attention of anyone interested in the shape of faith-based public advocacy. Besides well-crafted words, committed religious leaders are the authors of richly symbolic actions, so from words to actions, that communicate ethical values and express resistance to morally objectionable policies. Just to stay with the U.S. bishops for now, numerous prelates have put their bodies on the line, appearing, for example, at detention facilities to signal their solidarity with arrested migrants and opposing the violent crackdowns by federal officials. Ash Wednesday found Cardinal Supich and Joseph Tobin of Newark spending a day with ICE detainees and their families at a lockup. And I just want to raise the voice of Sister Norma Pimentel. She has been called Pope Francis's favorite nun for her great work with the Rio Grande Valley Catholic Charities, and they've cut off her funding. They've done everything to frustrate her work, and she keeps going. And I just can't be more impressed by any courageous person fighting against breaches of the rule of law. She accompanies the poor, and that speaks so eloquently more than any bishop's statement. Okay, I only have 3 paragraphs. Can I get them in? Okay. So far, I have relied on examples only of Roman Catholicism, which I happen to know best. But I have a long paragraph about the black churches, just to say these black, mostly Protestant churches have been wonderful exemplars. The funeral last week of Jesse Jackson reminded us all, at least it reminded me, of the wonderful activism for social justice. Remember the name of his coalition, the Rainbow Push Coalition, whimsically involving a rainbow and a active verb like push. I just love that. And that reminded all of us of the courage expressed by the black churches when their issues, racial discrimination, are at stake, but when other people's issues, labor and migrants, are at stake as well. Okay, well, this is my final paragraph. Okay, don't cut me off with that. We've started off on a good foot. Let's keep it that way. My final paragraph is this. Not all efforts of religious advocacy are so direct as I have been describing. The ministries of education and personal formation undertaken by every religious community I've ever encountered, they seek to shape the moral character of people, creating the reservoir of personal virtue, of civility, of sensitivity to the common good that are indispensable for any healthy democracy. Religious communities in our country maintain an impressive institutional base to shape the present and future generations as well. The future, that's where it's at. But it's probably not when religiously minded people wear their faith-based hats in an explicit way that they most often take the most effective actions to restrain bad actors or to hold public officials to their oaths to support and defend the Constitution. They probably do so, for the most part, in their secular capacity as citizens and voters, maybe even as journalists or as whistleblowers. But as I proposed at the outset, respect for the civil law does display a certain affinity with religious devotion. Remember the words of the psalm, "How I love your law, O Lord." Religious devotion fills a gap in our political culture that nothing else can. Indeed, if a renewal in adherence to the rule of law is to come, a good place to start might be with the call of Pope Francis, it's a chapter title in Fratelli Tutti, for a better kind of politics, one oriented to the common good. That's my last words, except for this. I have a couple of paragraphs that are too achingly optimistic to end on, but we're approaching St. Patrick's Day, right? Is it next Tuesday? So I had to be mindful of these two Irish poets. You know them better than me, and they speak at cross purposes, as all good Irishmen do. One, William Butler Yeats with his famous, in the Second Coming, "Things fall apart, the center cannot hold," but probably better, Seamus Heaney's in The Cure at Troy, the final couple of paragraphs. History says, don't hope on this side of the grave, but then once in a lifetime, that longed-for tidal wave of justice can rise up, and hope in history can rhyme. That's not too achingly. There you go. So thank you very much.
Thank you so much to all of you for those incredible comments. It's really wonderful. So I'd now like to give all of you the opportunity to speak to each other if there are particular questions or thoughts that were raised by the comments. And I'd like to, maybe we can go down the line and then go again to see how you respond to each other. Does that make sense?
Thanks. I'll speak only to Aziz. We're old friends, and we've been in conversation for a long time. And I've not heard before, and find really brilliant and incisive your account of the Supreme Court as a hinge institution, which, because of its role in the mid-century broadly liberal regime, plays a kind of legitimating and distracting role in the contemporary moment. At the same time, I wasn't sure it tracked for me phenomenologically. I have the sense, both from statistics and from kind of casual empirics, both that the general trust in the court is greatly down, and that the court is seen more and more by the kinds of people who are engaged with the ethical stakes of the moment as being itself on trial in its taking up of these questions. So I wonder whether you have the sense that this is something that is shifting, and if so, what next? I mean, you don't want us to reply immediately, is that right, or you do?
You could do a quick reply, and then I will kind of continue on
Yeah.
that line, and then comment again.
So first I should say that particular argument about the role of courts and authoritarianism writ large in comparative perspective is being done by a friend and colleague of both of our, do I have this on? Yeah. Friend of colleague of both of ours, and that's Madhav Khosla. So Madhav has been really interested in the role of courts in authoritarian transition, in other words, in de-democratization. So in India, in Turkey, in Hungary, and in the US as well. And so in a way, this was basically a kind of gloss on some of those ideas. But the thing that I was interested in specifically is that I think the US Supreme Court is playing this interesting dual role, where on the one hand, I think it's absolutely the case that the legitimacy of the Supreme Court is at its lowest ebb really since, frankly, 1936 and before the New Deal revolution in court jurisprudence, in basically a century. And so there's a way in which there's now a general sort of sense of the court as a explicit political operator. I was teaching constitutional law this morning. We were talking about voting rights. And it's really tough in conversation with students, and this is what students say to me after class, to not sort of just devolve back into an argument that Justice Roberts and others are making just plainly political arguments to defend the Republican Party. So I think that's absolutely the case. But there's this other thing, and it's the thing that I've been really worried about, frankly, over this last year plus, especially in the context of immigration and foreign policy, which is there is a long-term transformation in the nature of the court's jurisprudence that the Supreme Court has played a central role in basically saying that there's a whole range of activities that we can think of as just squarely violence committed by the state that is not a matter for the law to address. And what this has done is, I think it's acculturated Americans to just a presumption of a kind of impunity. So if you have presidents engage in extrajudicial killings, that's not something that the law deals with. If you have presidents that just round people up and then send them to third countries or detain them in conditions that by all accounts are cruel and unusual, that is just not something that the law deals with. And that's been a long-term project of the court, but it's very much a project of this Supreme Court, and I believe it's had a genuinely dulling effect on our moral faculties. Like, we're living in a moment where, yes, there's been a lot of outrage and there's been organizing when violence is seen in people's own communities, like in Minneapolis. But when it's not there and present, the debate about it almost always devolves into, well, was that illegal? And then you say, well, the doctrine says it's not really clear that the president has this kind of deference, or isn't there this immunity, and is it in the core component of what the executive power, that is not an ethically rich conversation about the nature of violence. And if that is the nature of the conversation that we're participating in, effectively what that does mean is that even this Supreme Court, that by another account, we're like, well, wait a second, this court, it seems to be a political product of the far right, and we should be deeply suspicious of it. We've still handed over our moral faculties to it, so that we're living in this moment where violence proceeds with impunity, and the conversation, to the extent that the conversation primarily exists, it's like, can he do it? Can he not do it? Nonetheless, it just goes on. And that's something that has to, I think, be pretty profoundly confronted as not just a question of the law, but a question of what kind of community we want to be part of and to what extent we want to be complicit in extreme acts of violence carried out in our own name.
Now you have the opportunity to ask.
So the question I had was for Thomas, and thought it was just really kind of stirring reflections. And in some ways, maybe because I was thinking about the Supreme Court and the brief that you were describing, I couldn't help but note that there's this really interesting moment where I feel like what we're seeing playing out is an internal fight over both theology and ethics. And so maybe this is actually a question for both Michelle and Thomas over what the role of the Catholic Church will be in promoting a vision of the good. Is it that integralist vision, which in some ways seems to have a kind of minoritarian strand? It's not like the majority perspective, at least as presented by the bishops. But on the other hand, it's dominant on the U.S. Supreme Court. It has a seat at the table with the U.S. Vice President. So, what do we make, how should we navigate, especially for folks that might be outside of those conversations, the nature of these internal tensions?
No, it's for you. The situation in Germany is different.
Yeah, well, that's the very point. That the most interesting topic in my mind these days, I wake up in the morning wanting an answer to this question, and I never get it. It has to do, is there a word, comparative legal studies? Is there such a thing? What about comparative religious activism studies? What I really want to know is, I need to do more research here. How other episodes in history, in other cultural contexts, besides the U.S., where we've had a very passive episcopacy, how have other places, and I know that German bishops are doing some really interesting things. You could tell us the story. And I'll just say this, the most interesting paper I've been to at any conference in 20 years was 2 months ago in Washington, D.C., when my good friend Agnes Brazal from the De La Salle University in Manila, Philippines, and she's sitting in the corner there. She's a visiting scholar here at BC this semester. She gave a paper on the people power revolution, the mid-'80s, unseated Marcos. I quoted that. How did that succeed where so many other Catholic efforts to engage in activism did not succeed? And here's my plug for America Magazine, Sam Sawyer. 2 issues back in January, there was a wonderful, almost 10-page article by, is it Maria Stefan? I never knew her work before. I'll have to look up her book. And it's called When Catholics Opposed Authoritarianism. And there are cases where Catholics did that, but there are cases like in Franco's Spain, where it didn't do that for 50 years. So I want to know the comparative legal aspects. And of course, I want to look to Germany because interesting things are happening there.
Yeah, perhaps only a very short comment. The paper I mentioned is really important. Before it is like a working paper now in every Catholic movement, in every parish, how to deal with AFD members within the movement or the parish or wherever, and it's really, really important. And another example, in September we will have elections in an eastern state of Germany, Sachsen-Anhalt, and there it could be the first time that the AfD will gain the absolute majority. And, well, the Catholic Church is not a very important factor. There's very few Catholics, yeah? But all Catholic movements, agencies, the bishops, they are building a kind of network now, a kind of a special movement to mobilize people against the threat of the AfD, and trying to do also formation. What will be the consequences? Because people don't realize what will be the consequences if the AfD will get into power. And it's really important what is happening right there. And in Germany, everyone is watching to the US. Oh, it's so terrible what is happening there. But in Germany, well, we are some steps behind, but it's not really not a good development we are experiencing at the moment.
Thank you. And Michelle, I don't know if you have a theme or a question that you wanted to share also.
Yeah, one short comment, because I was really happy about what you said about symbolic actions. Yeah, that's what we also notice from Germany and what is happening here. This is very important, and I liked very much, if you see something, say something. That's what we all should do right now. But I have a question to you. You talked about that society. Civil society activism is based on something like a common ethical vision. And now in Germany, in sociology, there is a very pessimistic analysis on what is happening with this common base, yeah, that, well, it is getting lost and it is losing its power, its emancipatory potential. And my question is, where do you see it? Where could it come from right now?
So do you want to start? Why don't you start, and then I'll, because given that it's connected to the points about trust.
I'm afraid I'm going to make it worse and then hand it over to Aziz. Because, again, trying to speak phenomenologically, my sense is not exactly that, and I don't think you said this, but one could have heard this, that there's a disappearance of communities of political conviction and engagement, or that people speak their convictions with less conviction. But there is, I think, a loss of this felt sense that your convictions also have a hold on those you're criticizing. That, I think, is a very deep shift in the experience of politics from the creedal, if I can make consensus period, from the sort of mid-century settlement. There was actually some widely shared felt sense of mutual accountability for the limits, and when the limits were invoked, that meant something. Like, that has to have been true, otherwise it wasn't a thing. And I think it really, really was true. And it's really not true anymore. And I think this is a kind of bind that activists and just citizens find themselves living in. Like, yes, you denounce with conviction that which is happening, but you also actually just don't believe it's going to matter at all to the people who are doing it. So that's, I'm sort of trying to specify what we're talking about. There's a lot of conviction, but the kind of commonality in force, or the generality, the extent and force of what's invoked is not there. And that's really, really hard. I think we could call it nihilism in a specific sense. That's something that previously had, by virtue of its status as an available conviction, a certain kind of suasive force. It loses that force. That just falls away. And I'm also quite concerned about the forms of socialization that come in the absence of the kinds of socialization that you're talking about. Because I think, again, you didn't say this, but one could have imagined that they're sort of describing a post-socialization world, but I think what we actually see, and I think we probably both think this, is that new modes of socialization are creating very intense kinds of political engagement with a different set of emotional registers and postures, a different way of seeing opponents, a different sense of what we do or don't have in common when we come into politics. And I'm being too abstract. I think that social media is very, very bad for the emotional structure and the ideological range of politics. I think it needs to be fully recognized as a mode of socialization, and a mode of socialization in which, among other things, to name briefly the political economy of all of this, significant aspects of our civic identity come to be side effects of for-profit algorithms, technologies for holding our attention, and that, I think, is a very grave situation.
So I agree completely, and I think that's a really essential clarification. So it's not that people are not believing deeply, but in context in which they don't presume that they can persuade, and they also don't presume that they share a kind of common vocabulary and common set of values and conviction, which ends up undermining, broadly speaking, a commitment to shared humanity. And one of the ways that I've been thinking about this, both in terms of the nature of the problem and also how to respond to it, is through the issue of segregation. And we can think of this specifically about racial segregation, but more generally. That when you go back to the mid-20th century and you think about people like Boston's own A. Philip Randolph, the great Black American labor leader, or Bayard Rustin, or Martin Luther King, they were strong proponents of integration, desegregation, but not actually principally because of the reasons that are typically presented. Where like the reasons that are typically presented oftentimes in the context of schools is like somehow this is going to be better for minority students to be in settings in which they're with students of different backgrounds, or for students of different backgrounds to experience like a diversity of perspectives. Like that was not the argument. The argument was that the system of segregation was a conscious effort to break the possibility of cross-group solidarity and a vision of shared humanity. They said the reason why segregation laws emerge in the 1890s specifically is because it was against the backdrop of cross-racial populist organizing in the South, whose purpose was precisely to organize people across different races that were neighbors. A black tenant farmer lived next to a white tenant farmer. They had the same social experiences. They interacted with each other extensively, and they understood themselves as facing the same basic predicaments. And out of those predicaments, they developed an idea of solidarity. And what segregation did is it made it incredibly difficult for folks across difference to understand themselves as part of community. And really, one of the great achievements of the mid-20th century in entrenching that constitutional compact was actually desegregation. Like in the 1980s, when I was going to primary school, my public schools in the state of New York were more desegregated really than they'd been in, than essentially had ever been. The desegregation numbers were remarkable. And the story of the last 40 years has been the systematic resegregation on racial lines of collective life in ways that make it very difficult precisely to engage in these forms of cross-group solidarity. And then if you expand it out through social media, through the balkanization of collective life, segregation as a principle of the isolation of groups into in-groups that see others as out-groups has become the defining feature of the American experience. And to the extent that it's the defining feature of the American experience, it doesn't mean that folks that you disagree with aren't invoking arguments from like ethical claims. It's that the kind of ethics that's pervasive is not the ethics that I was associating with that mid-century rule of law, which is one that presumes equal and effective freedom for all, a shared vision of dignity, that understands forms of violence as a repudiation of that shared humanity and as an act of one's own moral degradation. Like it's a specific vision of ethics that's tied to a world that's genuinely integrated. And what it highlights is, it might not be the first thing you think of, but pushing for schools and neighborhoods and forms of housing and workplaces that are in fact integrated in the way that one imagined from a Philip Randolph in the 1950s is a really critical tool of altering our own moral vocabulary and moral experiences.
So we need to turn to table talk, but Thomas, I wanted to give you the opportunity to throw out a theme if you had one quickly.
Yeah, a really quick thing, maybe 2 or 3 sentences each from Jed and Aziz, and I think Odette too. How can we demystify law a little bit for the lay people like me? So Kathy Caven, I would never say no to her, any invitation from her, but when she said the conference was on the rule of law, I was like, oh, I don't know, I'm a little allergic to that. And then I softened because I met my 26-year-old niece at Christmas time, and she came, we never had a lawyer in the Massaro family, she came from first semester of Temple Law School. And it didn't ruin her. She's fine. She's good. And then I read the amicus curiae brief. I've never read a legal brief before. I loved it. I'm going to share it with my students at Fordham. So are there ways, this is a good thing, right? Are there ways for us to demystify law for lay people like me?
3 seconds each. Let's start off that side.
No, I'm not allowed.
Yeah, I think this is for the 3 of us. But do you want to go, or do you want me to go? Yeah. So I guess my initial point is that I think the main thing that I would say in response is that there's a way in which law is a stand-in for our moral convictions. So when like a layperson, a person that is not a lawyer, says that's unconstitutional, what they're not really saying is, like, I did this extensive analysis of, we were just doing this in con law today, of Section 5 of the 14th Amendment, and I've come to a conclusion that, like, the doctrine is not consistent with how I view the current case law. What they're saying is that their vision of the kind of world that they want to live in does not seem to be expressed in the types of practices that individuals are engaged in. And above all, really when we're talking about the rule of law, the argument is it cannot be the case that we live in a world in which those in power can exempt themselves from the rules that others have to follow, and in the process impose violence on their enemies and then provide profit to their friends. Like, that's really it when it comes down to it. And that means that I think there's a responsibility for the legal profession to provide a mechanism for ensuring that the legal system actually embodies those values. And I think the problem that you're highlighting is so much of law, including of constitutional law specifically, because it's my field, is instead about a technical analysis of a particular bit of text in ways that has an obfuscating effect on precisely what folks expect or want from a document like the Constitution or from the law. And so what I think it speaks to is that it's the responsibility of lawyers, especially in the US, when lawyers play such a central role as intermediaries between the state and their ordinary experiences, precisely to be able to translate what is the lay assessment of what these documents are meant to mean into the terms of the conversation that takes place.
I completely agree with all of that. I think that's great. I actually want to add something that is a bit more following on the last exchange that we had. And it's just this. On point of segregation and increasingly sort of ideological segregation as a sort of master theme of American life, which I really think is right. It's really just this. I want to pose a question for self-scrutiny for all of us. It's one I try to pose to myself, I think not very successfully. I would just pose it in this way. If I accurately think that there are general conditions in social and cultural formation that are making the characteristic attitudes and emotional structures and postures of our politics and the culture from which it's downstream much worse, it is unlikely that all of the symptoms are concentrated among people I disagree with and movements I think terrible. And then I just want to kind of pose that, because I think if that explanation is right, then its effects can't be isolated on one side of ideological division. And I don't want to moralize about that. I'm not sure what to do with that, but I think everyone starting with me, that's just something one needs to think with if one thinks that sequence of thought is right.
Yes, no, I'm going to try to be brief, and I've never been asked this question, and as dean, I'm really in the business of mystification, taking lay people and then teaching them all the jargon. But maybe at the simplest, it is something like taking do unto others as you would have them do unto you, and then putting that into an incredibly complex world in which the outcome of that precept is not always clear, right? Taking that, and how do you do that in tax law? How would you do that in international economic law? How would you do that in the context of corporate restructuring, right? And then making those laws generalizable, transparent, and allowing people to then organize their lives in a way in which there's a complex legal system that I think at its base, at its best, it's my hope, captures some of that. So let's, with that, give that out to all of you to talk amongst yourselves for 10 minutes, something like that, and then bring it back in. Thank you so much for what seems to have been really deep engagement in your tables. Now, I know we are supposed to be wrapping up very, very shortly. I did want to maybe collect some questions from the floor, and then maybe collect a small number of questions from the floor without letting our panelists respond one by one, and then returning to them to answer any questions that might have been directed to them very, very quickly.
This question is for Dr. Purdy, mainly. You brought up the etymology of democracy, demos and kratos, but there's no pre-political definition of the people. So who is this demos that can then go make laws is a question that can't be answered democratically. So how do we untangle that knot?
You're just collecting questions
we're
now.
collecting, and then-
Yeah, this is to both Aziz and Jed. Why talk about the Supreme Court rather than the district courts? I mean, the Supreme Court is at war with the district courts, but the district courts have been heroes, and they talk in moral language. They talk about cruelty. They talk about the unbridled search for power. Judge Byery ends with a photo after he has liberated the 5-year-old who was arrested in Minneapolis and shipped off to Texas. He ends his short order with a photo of the 5-year-old in his little bunny hat and 2 biblical quotations, one about hindering not the children, and the other, Jesus wept. That is, it seems to me, a kind of heroic resistance. Now, what's going to happen is that the Supreme Court is going to say, we're the boss. You fall in line. I think the district judges are going to find themselves in the same boat, so to speak, as U.S. naval personnel who were ordered to commit illegal acts. You have to decide, what am I going to do when a hierarchical superior gives me a plainly wrong, immoral order or illegal order? I mean, interesting that at West Point they tell officers moral as well as legal, or they used to. They stopped this in the current administration. So I think that part of the resistance that we're seeing is coming from judges at the district court level. But for the Supreme Court, I'm kind of with Leah Littman. They run on right-wing grievances, conspiracy theories, and bad vibes. I mean, her famous no law, just vibes.
I think we had a over here. Oh, you pick, Greg.
I'll come back.
Okay.
Hi, Aristotle Papanicolaou Fordham. But so you mentioned the common humanity, and I'm all for the common humanity. And I'm wondering with Aziz and Jebediah whether there's a two really quick questions. Whether there's a difference between common humanity and the common good. And, you know, the idea of common humanity has come under fire from the left, right? I mean, it's, you know, any mention of common humanity is somehow embroiled in power structures, who is common humanity, and so on and so forth. So are we living in a moment with polarization where maybe that word will be resurrected as politically useful, or many strategies on how to do that, how to rally around common humanity? So,
do you want to take one more and then?
Yeah, let's do one more.
Thank you very much. I think this is going to be a little bit of an answer to Thomas's point about how we demystify the law or how we go forward, which is, you know, on top of mind for all of us after these days. And it's a question about whether we can't mimic to a certain extent or follow the successful pattern of the Federalist Society, which, including my colleague at Notre Dame, who's played an outsized role in 5 Supreme Court justices being on the court. And they were willing over a 30-year period to put into place their structure that has resulted in the Supreme Court we have today. And my long game is in legal education, because I want to add one point to Aziz's assessment as genealogy of how we got here. After the Second World War, we did do a lot of building of constitutions and systems within countries that had been under authoritarianism. But at the international level, the United States, which still had incredibly knowledgeable international lawyers who drew on the natural law tradition, who understood deeply that this was a common bond of humanity, that we could bring all basic moral and philosophical systems into that law that we had had since time immemorial. That's the law that underlies the United Nations Charter, the Nuremberg Charter, the Universal Declaration on Human Rights, the Geneva Conventions, and NATO, which is based on Article 51 of the UN Charter. We had deep knowledge, but by the time of the 1960s, due to reasons that I talked about yesterday, we had turned inward and we were not interested in this world law. By the time of the end of the Cold War, we don't have deeply knowledgeable international law people in this country based on the classical understanding of international law, and therefore we are not in a position now to get the refreshment of our own law from the resources of other countries. My amazing colleague Diane Desierto from the Philippines told us all at a conference a year and a half ago, as it was clear which way the elections were going, do not, so I grew up, she says, I was born and raised in a dictatorship, and we struggled every day against it, people power, which we talked about, and we had international law as our anchor, as our touchstone. It was outside our corrupted system, and we knew what we should aim for. But of course, the Philippines had amazing international lawyers who kept that faith alive. They were Catholic trained, they could bring in, they understood natural law, the basis of international law, and they understood Catholic social teaching. So I'm going to suggest at this great law school, this great university, that we start really recruiting, especially from abroad, where people still have a really amazing education in international law, to the United States.
Thank you. So I think maybe very quick set of responses, if you could, from the table, and then I think we'll close the formal session. And if anyone is available afterwards, you could stay, I think, but yeah.
I agree with everything that David Luban said about the district courts. Andy, I think it's a very profound question, which indeed has no answers internal to this kind of reasoning. I think it's not accidental that we live, in a sense, in accidental, or at least contingent political communities, and it's within those that we have to try to articulate the commitments we do. I don't think we can get behind our own historical shadow altogether in that sense, at least not ultimately. Telly, for the same kind of reason, I, in a sense, I think of more concrete kinds of common good civic as the settings in which versions of common humanity, which might extend beyond those and give us resources for deepening those, can be articulated. But indeed, those do seem to be different registers and part in the sort of scope of their catchment. And I think I share your intuition that the language of common humanity might be a resource worth the recovering right now, despite, and maybe with some instruction from all of the flack that it's caught. That's all I have to say. Thank you all.
So, quickly, I also agree on the role of the district courts. I think the reason why I focused on in my time that I didn't have a chance to go through the district court role was because of what you also said about how unfortunately so many of these cases are ending up at the Supreme Court, and so that there's like an outsized power that the Supreme Court plays. Though I think the thing that you were highlighting is really important, namely the fact that what's happened at the district court level is not tied to partisan ideology. So you're having Republican appointed judges that are making these moral arguments. Critically, these are judges that are older, that are appointed by Reagan, by Bush Sr., and in a way, they speak to that earlier era of bipartisan commitment to that compact. And I think one of the things that it speaks to is both the capacity of the court still to serve as a site of constraint, but also that there's a lot of cultural depth for the ideas of the rule of law that I was articulating that exist within judges, within the legal profession, within the medical profession, within unions, and that in a way, I think part of the problem of the present is that there's been a basic presumption that those institutions and actors will not have to, in fact, take risks or be out in front to engage in various kinds of constraints on like deleterious behavior. And that actually it turns out we need active state bar associations, something that we were talking about last night. We need like active unions, like active collections of lawyers, law firm activity. And in a way, it's like how to take advantage of that depth of commitment. Very quickly on the shared, I was using the language of shared humanity, but so common humanity, common good. Rather than language, my own perspective, and maybe this is informed by what Marianne was just saying about international law, is that I'm personally deeply wary of various politics of nationalism, and especially like closed nationalisms. And so to the extent that the language, for instance, of the common good veers in terms of really thinking of a restrictive demos as the relevant site of effective attachment, like I find that deeply troubling. And so for both an account of shared humanity and the common good, I'd want to be able to invite precisely the principles of international law that are grounded in a notion of a much broader way of thinking of community as the basis for law.
Only a very short comment also to the question on the shared or common humanity. Of course, there's also the problem, and I think you mentioned it, that speaking of humanity, shared humanity, or something similar, is the danger of ignoring differences between humans. But for me, it was very helpful, the concept of Dipesh Chakrabarty, who exactly explains, yeah, there is a danger, and we have to take care of all the differences. But we are facing so many crises and problems in the world that we need as a conceptual, a kind of a strategic concept of humanity, shared humanity, to face the problems together without ignoring the differences.
Looks like I get the last word of the panel and the conference. So Mary Ellen used the word I was going to use anyway, the long game, right? In the parts of my talk that I X'd out at the last minute, I have a lot of language about the long haul and doing moral theology and doing legal ethics for the long haul. And all I want to say is let's keep our eyes on not this next election or the election after that, there's going to be a lot of cleanup that's going to go on for a long time. I live in a neighborhood of the Bronx where there's a lot of what we call smash and grab robberies. Jewelry stores get smashed overnight, people grab out. It takes those store owners a long time to clean up, not just sweep the glass shards and get a new window. You can imagine how long it takes to get their business back on the right foot. So be ready for that. I believe the religious community as well as the legal community, I love the idea of bar associations having some say. Build the institutions, Robert Putnam and all, that will give us the long haul and do the work of cleaning up that's going to have to happen at some point.
Thank you so much to our panelists, mindful of this one, that this one has a flight that he has to catch. So thank you really to all of you.